Assalamualaikum and welcome back for the uh, lecture online for the engineers in society. Today we will cover on the rules and regulation. Continuation from the last week. Last week we covered the laws and contract law, and today we are going to go into the Registration of Engineers Act and all those related acts. And now I'm going to share the slides. So all of you should download the slide 5A and 5B. Yeah? And next week, we'll go back into the slide 4A, B, C, and D, which are related to the Code of Ethics. So I'm trying to cover all the material regarding to the laws and regulation first. Then after that, we go into the Code of Ethics, and we go into the case studies after that. At the end, towards the end of the semester, because the case studies actually will carry a lot of marks in your final exam. About 2 questions out of 5 questions, I think. Yeah. So that carries a lot of marks there. And so we will cover that in quite detail. So now I'm going to share the slides on the Acts, regulations, and engineering standards. Everybody can see the slides? I hope all of you can see.
Yes, sir.
Okay. Okay. So, professional obligation to SOP, standard operating procedures. Basically, that as a professional, we have certain obligation to our profession, just like I said in the early of the semester. Regulatory standards and standards of competence are intended to provide some assurance of quality, safety, and efficiency in engineering. So all the regulatory standards were being set by the industry or by the government actually to provide assurance to the client or to the customers with regards to the quality, safety, and efficiency in the engineering. And also, and besides the regulatory standards, we also have the engineering codes of ethics. This engineering code of ethics, basically that is a statement about engineers being required to conform to accepted standards of engineering practice. So engineering code of ethics, it can be embedded into the laws, into the Act of Parliament, such as in Malaysia that we have Engineers Act, or it can be the code of conduct prepared by the body which govern the engineering profession. For example, you have IEEE Code of Ethics, you have Mechanical Engineering Code of Ethics, you have IEM Code of Ethics. So you have all those engineering code of ethics. Okay, these are the acts, regulation, and engineering standards which relates to the engineering profession in Malaysia. So you have Registration of Engineers Act 1967 and the Regulation 1990. You have Contract Acts, which we covered last week. We have Electricity Supply Act 1990 and the Regulation 1994 and 1998. We have Occupational Safety and Health Act 1994 and the regulations. And also we have certain departments in the government which responsible for maintaining or coming up with the standards with regards to the engineering. This actually under the Department of Standards Malaysia and also SIRIM. So these are the two bodies which are responsible for maintaining the standards in Malaysia. Right? So we will go briefly after this about these two entities. So we go to Registration of Engineers Act 1967. Right? So this act actually provide for the registration of engineers. All the individuals who want to practice as an engineer in the engineering field must register with the Board of Engineers. So they must register. But for this, actually, you have to have certain what I call it qualification and whatnot. Not anybody can be an engineer. It's also provide for the registration of sole proprietorships. Sole proprietorship is actually a enterprise company in Malaysia. It's under registrar of business. Partnership. Partnership also can be a business. And bodies corporate. Bodies corporate is a company. Sendian Berhad or Berhad company. Sole proprietorship and partnership, those can be business or enterprise, which providing professional engineering services and for purposes connected therewith. So individual engineers, enterprise as a business, partnership, whether it's business or company, bodies corporate, which is a company, whether it's limited, limited, which is Sendian Berhad or Berhad. And if these four entities want to provide the engineering services or anything connected to it, they must register under this act. That is what this act is for. For the employment as an engineer in Malaysia, the registration with Board of Engineers as a graduate engineer falls under the Section 10(1) of Registration of Engineers Act 1967, which says that subject to this act, any person who holds the qualification required for graduate membership of the institution of engineers or such other qualification as the board consider to be equivalent thereto shall be entitled on application to be registered as a graduate engineer. So anybody who has graduated from accredited university, for example, or equivalent to that, shall be entitled to be registered as graduate engineer. To be registered as a graduate engineer, he must apply. So application must be made in order to be registered. So the registration as a graduate engineer is not automatic. Clear?
Clear.
Okay. On the section B, it says that subject to this act, a person who is registered as a graduate engineer under the previous paragraph, in paragraph A, shall be required to obtain such practical experience as may be prescribed by the board after consultation with the minister in order to be entitled to apply for registration as a professional engineer under subsection 2. So this act is very general. It says that you need to have after you have registered as a graduate engineer, you are required to obtain practical experience. So this act does not tell you how many years. Okay? how many years that you require actually is decided by the board of engineers. So basically the board of engineers are being given the power by the law to decide how many years. So in this case, board of engineers decide to be 3 years minimum, right? The one that I mentioned in previous in the earlier part of the semester. Remember that after you have graduated, you have to work minimum of 3 years under a professional engineer. So that is actually related to this part of the law. And basically that the board set that requirement based on the consultation with the minister. So which minister? So in this case, the board of engineers is under which ministry? Kerja Raya, right? So that's why the office of board of engineers is at the JKR, bangunan JKR, Jalan Sultan Hishamuddin. So the Ministry of Works, basically that responsible for this act. So he has the power over the registration of the engineers. So you have to work with you have to obtain practical experience in order to be entitled to apply for registration as professional engineer under subsection 2. So let's see. So under the subsection 2, we will go later, I think. And I think I have covered previously in the process. So now we go to the regulation of 1990. So this is under the regulation of 1990. The important part is the part 4, which is with regards to the Code of Professional Conduct. This regulation spells out what you can do and what you cannot do. So I take the part which is more important for this course, which is the Code of Professional Conduct. So start with the section with the Article 23 or Perkara or Section 23. It says that every registered engineer shall at all times uphold the dignity, high standing, and reputation of his profession. So all the engineers registered under Board of Engineers must uphold the dignity, high standing, and reputation of the engineering profession. That is the first one. Second, a registered engineer in his responsibility to his employer, client, or profession shall have full regard to the public interest. So first, actually uphold the dignity, high standard, and reputation of the engineering profession. And second, while discharging your responsibility to your employer or to your client or to the profession in general, you must have the interest, the public interest as your consideration. You cannot jeopardize the public interest. Section 25, it says that, Section 5.1, a registered engineer shall discharge his duties to his employer or client as the case may be with complete fidelity. So basically that he has to discharge as honestly as possible with regards to his responsibility as a professional engineer or as an engineer. 25.2, except with the permission of his employer, a registered engineer shall not accept any remuneration for services rendered other than from his employer. Basically that if you are employed by a company, you cannot accept payment from any other entities except if your employer says that yes, you can. So you cannot get two payments for one job. One is from your client, another one is from your employer. Cannot. So only your employer can pay you. Okay. 26. A registered engineer shall not maliciously injure or attempt to maliciously injure, whether directly or indirectly, the professional reputation, prospect, or business of another registered engineer. So basically that you cannot steal the job of other engineers, or you try to jeopardize his reputation, or by talking bad about him, about his reputation. Cannot. So you have a code of conduct, professional conduct that you have to follow. You cannot say bad things about your fellow engineers. Okay, whether you do it directly or indirectly. Cannot. 27. A registered engineer shall not canvassing and advertising prohibited. So you cannot lobby for the projects, for example, for the job. Canvass or solicit professional employment, offer to make by way of commission or any other payment for introduction of his professional employment. So you cannot give commission so that people will recommend you to a company to engage you as a consultant. No, you cannot do that. Except as permitted by the board, advertise in any manner or form in connection with his profession. You cannot advertise about your services in the newspaper or anywhere else, unless if the board of engineers give you permission to do that. You also cannot provide professional engineering services to any person unless the scope of such services are clearly defined in a written agreement between both parties. You can only provide your services to your client if that services is actually written in agreement and being agreed between you and the client. Anything that outside of that scope, you are not allowed to provide. 28. A registered engineer in an engineering consultancy practice shall not practice engineering with any person who registered has been cancelled. So basically that you cannot practice engineering with an engineer which his registration has been cancelled by the board. He is no more a professional engineer. He has not registered with the board of engineers. Right? This is actually for the registered engineer in engineering consultancy practice. An engineer who has a company, a consulting company, and he cannot hire an engineer, a person who his registration has been cancelled. Or he cannot hire somebody who is not registered with the board of engineer to become an engineer. A registered engineer, number 20, section 29, a registered engineer in an engineering consultancy practice shall not be a medium of payment made on his client's behalf. So, an engineer who works in a consulting company cannot accept payment on his client's behalf, unless he is so requested by his client, nor shall he, in connection with work on which he is employed, place contract or orders except with the authority of and on behalf of his client. So basically that the engineer, if you work with a consulting company, if your client not requested you to do anything, you cannot do that particular task. Item 30 is deleted. Item 31, a registered engineer shall not directly or indirectly supplant or attempt to supplant another registered engineer. Ini tak boleh sailang lah, another engineer. So you cannot try to take away another engineer's job. Or you cannot intervene or attempt to intervene in or in a connection with engineering work of any kind which to his knowledge has already been entrusted to another registered engineer. Jangan kacau another engineer, registered engineer's job. C, take over, ambil alih any work of that other engineer, registered engineer acting for the same client, unless he has obtained the consent of that other registered engineer. Basically, you cannot ambil alih kerja yang sedang dilakukan oleh other registered engineer, kecuali dia dah bagi kebenaran. Kedua, have been formally notified by the client that the services of that registered engineer has been terminated. Second condition that you can ambil alih tugas other registered engineer is apabila client tu dah inform you that that particular engineer has been terminated. Then you can. Okay, clear so far? This part is, all these are important because in one of the question is always that in the case study you have to find which section that the engineer in that particular case has violated. So you need to clearly understand this code of professional conduct, all these numbers, which is section and whatnot. But of course, in the exam, we will give this code of professional conduct as an appendix for you to refer to. But you need to understand what these sections means. What does it mean, so that you can, so that you be able to recognize what are the violations that being done in the case studies later, or even in the test. Because what happens in the test, we give you a case study, you study, then the question will be asked with related to the code of professional conduct. 32.1, except with the prior approval of the board of a registered engineer in engineering consultancy practice shall not be a director or executive of or substantial shareholders in or agents for any contracting or manufacturing company or firm or business related to building or engineering. So basically that if you are involved as a consultant, and you cannot be a shareholder, the owner, or the director in the company which being awarded the project which you are a consultant. So basically there is a conflict of interest. You are a consultant, but you also supply for that project. Of course, because the consultant is going to approve of the product that is being manufactured, or the work has been done by the contractor. So basically that you as a consultant, you are approving your own product. So that is actually a conflict of interest. Therefore, you are not allowed to do that unless if the board of engineers give you the approval. Let's say maybe you are the only company that produce that particular part to be used in that project. Basically, no other company in the world produce that part. So therefore, definitely the board will give you approval, because without that part, that project will fail. So if in that kind of situation, therefore, you apply to the board. Okay, look, this part is vital to this project, and this is the company, the only company in the world that can produce that, and I am the owner of that company. So therefore, the board will give an approval. So, but you have to apply. Right? 32.2, if such approval is given, such registered engineer shall not undertake any contract work wherein he is engaged to provide professional engineering services in such project unless it is in respect to build, design and build. So only in design and build project that he can be the consultant or the designer and also the manufacturer. Okay? Only in design and build project. What is design and build? Design and build is basically that you are being given a project by a company, by your client, to do the design and also to build that particular product, for example. So you are not only design, but you build. Because sometimes most of the project basically that somebody else design and somebody else build. Design and build, sometimes we can need some other term that people use is turnkey project. Turnkey project basically that the client just come and turn the key, because everything else is being done by the contractor, starting from the design, building of the equipment, for example, then deliver. There are certain projects, we call it BOT, build, operate, and transfer. Some project is BOOT, build, own, operate, then transfer. So there are different types of the projects configuration. But in this case, design and build, you understand what design and build is good enough. Section 33, every registered engineer, while acting on his professional capacity, shall disclose in writing to his clients of the fact he is a director or member of or substantial shareholder in or agent for any contracting or manufacturing company or firm or business, or has any financial interest in any such company or firm or business with which he deals on behalf of his client. So basically that he has to disclose the information that he is actually, he has some shares in the company which are going to supply the products to the client. Okay, he cannot hide those information. So you see how the what we call it is very strict in terms of the professional conduct of an engineer. So all this actually is done to take care or to protect the integrity of the engineer and of the profession, so that to minimize the conflict of interest in the of the engineer in the particular project. Any question on the regulation 1990? Those are actually related to the engineering code of conduct. If not, I'm going to the next one, the Electricity Supply Act. Electricity Supply Act, basically that the act provide for the regulation of electricity supply industry, the supply of the electricity at the reasonable price, the licensing of any electrical installation, the control of any electrical installation, plant and equipment with respect to the matters relating to the safety of person, then the efficiency use of electricity and for purposes connected therewith. So this part actually the one that interest for the engineers is the safety, plant and equipment with respect to the matters relating to the safety of persons, and the efficiency use of the electricity and for purpose of connected therewith. And of course, you are students and in the power engineering, that you need to know this act, Electricity Supply Act, so that is quite related to your field of study. So I'm not going to go into detail of that, so because it will not be in the exam. But you have to be aware that there is an act, Electricity Supply Act, which actually the focus for in terms of the ethics is on the safety. The next one is occupational safety and health. This is really related to the safety in the workplace, which is also the engineer must be take into consideration when they do the design. So this act actually enacted in 1994 is taken care of by the Department of Occupational Safety and Health under Ministry of Human Resource. Okay. This act is really to ensure safety, health and welfare of all persons at all places of work. And the philosophy of the act is actually that responsibility for safety and health in the workplace lies with those who create the risk and those who work with the risk. So basically that the responsibility of safety and health, the responsibility of all, not just the employer or not just the employees, but both employers and the employees. So you as an engineer, most of the time that you are an employee. So you are also responsible for the safety and health in the workplace, and also the safety and health of your product or your product design. So the safety of the labs, for example, those are also falls under this act. Employers, as a rule, must follow the provision of the act, regulation and relevant codes of practices and guidelines, and follow best practice and advice. So the employers actually must implement all the regulations that is required by the code of practice and guidelines provided under this act or provided by the body who govern the occupational safety and health. Whereas the employees too must comply with the provision of the act and cooperate with the employers in their attempt to ensure a safe and healthy workplace. So each employers and employees have their own roles to play with regards to OSHA. It is a breach of the criminal law when certain provisions of the Act are infringed. Bila langgar, the provision dalam akta ni is a breach of the undang-undang jenayah. Not civil punya law, but this is actually you breach the jenayah. Those injured or diseased may bring about charges in civil courts when there is a breach of statutory duty under certain provision of the Act. So, if there is an injury, ada kecederaan apa semua, so actually the employer can be charged in court, can be sued in court for mahkamah sivil untuk bayar ganti rugi and whatnot. So basically that you can be liable for criminal and also can be sued in civil court. Dua-dua kena. This is actually a body which related to OSHA, which is National Institute of Occupational Safety and Health. The vision of this body is that to be the leading center of excellence in occupational safety and health. The mission is that to preferred partner in enhancing occupational safety and health. It was set up in 1992. So you can read this, the background. But that is the body related to that. Now, we go into a body which related to standards and industry in Malaysia. One is that the SIRIM. It's a governmentally wholly owned company. It contributes to the dynamic national economy, enabling Malaysian products and services to receive its due recognition of quality and innovativeness. So basically that SIRIM will endorse certain products which meeting the standards. So the role of SIRIM is actually as the National Research Technology Development Corporation, and it's actually a vehicle for technology transfer. Basically that SIRIM will acquire technology from overseas or develop technology on its own. Then after that, will transfer to the companies, local companies within Malaysia, in Malaysia. It also provides institutional and technical infrastructure. It also do testing. It has labs that you can go and test your product there. Sometimes the equipment is very expensive to buy. So those equipment actually available in SIRIM, and you go and can utilize that equipment at a certain fees. They will charge you certain amount of money. SIRIM is established in 1966 as a standard institution of Malaysia. In 1974, SIM formed with NISIR to become SIRIM, statutory body under Ministry of Science, Technology and Environment. And they have 13 member, board member in SIRIM, 6 private public sector, 7 private sector. At that time, now it's different already. Then in 1996, SIRIM is incorporated to become SIRIM Berhad. So until now, SIRIM is starting from 1996 until now, they are actually a corporate, SIRIM Berhad. So another one is that Department of Standard. This is actually a government body. So the Department of Standard Malaysia or or now called Standards Malaysia, is an agency under the ambit of MOSTI. Now it's basically is under, they call it MOSTI, Ministry of Science, Technology and Innovation. And now the minister is Khairi Jamaluddin. Standards Malaysia was officially launched in 1996 following the incorporation of standards, incorporation of SIRIM. Previously, SIRIM, before it becomes SIRIM Berhad, responsible for the standard for the government of Malaysia. When SIRIM is incorporated as SIRIM Berhad, therefore, the regulatory function is being taken away from SIRIM and given to a newly set up department, which is Department of Standards Malaysia. So that's how it actually evolved. So now we have Standard Malaysia took over the statutory role of the standardization, which is carried out by SIRIM. And SIRIM is doing the role of technology transfer, testing, and whatnot. But in reality, actually, the Department of Standard actually outsourced to SIRIM for doing the standards development and whatnot. I was involved in standards for biometric. I think about 14 standards that I was involved about almost 10 years ago, I think, more than 10 years ago, coming up with a standard for Malaysia for ISO standards on biometric. So that standard actually developed by SIRIM under the direction of Department of Standard Malaysia. So the mission of this department actually is that to provide credible standardization and accreditation services to enhance the economic, societal, and environmental well-being. In performing its duties and function, Standard Malaysia is governed by the Standard of Malaysia Act 1996. The function is basically management and development, status and benefits, accreditation and certification. And some of them actually outsourced to SIRIM. Any question on this part? No question, right?
No, sir.
Okay. I'm going to go into the next one. Then after that, we can stop for today. Okay. Which is the intellectual property. Okay, I'm going to share the slides on the intellectual property. And if you don't have any question, I will continue. Okay. Intellectual property. Okay. Everybody can see the slide on intellectual property?
Yes, sir.
Okay. Yes, sir. This is very fast. I'm not going to bore you lah. I just show you all the slides so that after this you can do your own search actually. So that during this PKP, you can do studies on your own. You can do you can look at the slides, the notes, and you can do the Google search and find certain articles which are related to the topic that I've mentioned in the slides. Okay. Intellectual property. What is the intellectual property? Intellectual property is actually is an intangible asset which regards to the with regards to the with regard to the ownership of the ideas, of the outcome from that ideas. So a lot of this intellectual property, basically, that the question is always who owns it? Who owns that IP? Intellectual property, we call it IP, intellectual property. Who owns it? If you work for a company, let's say, and your boss asks you to come up with a certain design, and it is your idea. It comes from your mind. It comes from your intellect. It comes from your training in the university. So you think that it is yours, right? Right? Because you are the one who's doing it. Your boss just asked you to do it, right? But is it really yours? So who owns it? So sometimes a company, even on the first day that you come to work, they will ask you to declare the list of the intellectual property that you own. Normally, they will ask you, have you hold any patents? So you have to list out all those patents. Have you hold any copyrights? You have to list out all those. Because the company basically that try to protect themselves from you using other people's property, IP, in coming up with a design for the company that you are going to work for. And if you don't list that in the form that they are prepared, then they can say that, okay, this person has not declared. And even, let's say that you own that property and you use that design in that company design, and then after that you want to declare, okay, this is actually you own, so the company should pay you certain royalties. The company will not do that if you don't declare that you are using your own prior IP that you hold. So when you show up for the first day of work at a new company, they will likely ask you to sign a contract that they own all the intellectual property that you create while on the payroll. As long as you are the employee of that company, whatever idea, whatever design belongs to that company. It's not yours. You may also have to sign a no-compete clause indicating that you will not work for a direct competitor for a given period of time after leaving the company. So you also sometimes that have to sign an agreement to say that when you resign from that company, you will not go and work for its competitor, maybe for 5 years, that you cannot work for its competitor. For example, when I work with Motorola, that I have to sign for the first part that they own the intellectual property that I've created, that I will create for Motorola. And I have to list out whether I have any prior patent or whatnot. For the second part, when I work for Sapura, I was not allowed to go and work to Sapura's competitor if I leave Sapura. So I have experienced both situation, right? For the second part, that you have no compete clause is actually to make sure that you don't bring their intellectual properties to another company, or your experience and whatnot that you have done in that company to be benefited by the competitor. So in order to prevent that, they have a no compete clause that you cannot work in a direct competitor for a given period of time. Most companies sometimes that will not allow you to work in your in the competitor's company for 3 years, for example, or 5 years. Any questions so far?
No, sir.
Okay. Intent of designing new product, which is to sell. Basically, when you design a new product, you want to sell those products. So intellectual property seeks to answer the question who owns the idea or the invention. The issue of legal liability, basically, which comes into play if somebody is injured or harmed by a product or system. So when you know who owns that product or that idea, that invention, then you can assign the liability to the owner of the intellect of the product or of the invention. So that's why it is important. Who owns that intellectual property? Because the legal liability will be assigned to the owner of that product or intellectual property. What are the IPs, the types of intellectual property? We have patent, we have copyright, we have trademark, we have industrial design, we have a geographical location, but in our scope, we are interested within the patent, copyright, trademark. Patent is that others cannot use design or idea without the permission of the owner. So you file a patent to claim that, okay, this novel design, this novel invention is yours. So therefore, other people cannot use this invention for their own purpose without getting permission from you. Copyright is actually to protect published work or work of art, normally books, articles, music, softwares, paintings. Another one is a trademark, which is to protect the registered symbols and design, logos, for example, right? Patents, actually legal protection for a design or invention. So, if you have a patent on a design and somebody else use it, the government will fine them and penalize them. Is that true or false? Is it true or false?
True, sir.
Who says true? Who says false?
True, sir. True.
True.
Sir, the government, the person can sue the other person. That means the person who initially made the patent is the plaintiff, and the person who copied the person's idea is the defendant.
So what does it mean? Is it true or false that the government will fine them and penalize them?
True, sir.
No,
Government cannot keep track of all these kind of issues that happen. So if that person comes to know, then that person can sue and bring to court.
but thus the government will fine them and penalize them. No.
False. False.
So the answer is false, because the government will not try to fine them and penalize them. It's actually up to the owner of the patent to file in the court to sue the person who infringed the patent. And you have to prove that that person has infringed your patent. And the government will not penalize them. What the court will do is that will ask if you can prove that the patent is yours, if you can prove that that person actually infringed on your patent, if you can prove that to the court, therefore the person who infringed your patent will be penalized by the courts. So basically, to pay you for the infringement that they have done. So basically, that they don't pay to the government, so the government will not penalize them. Okay. The second one, the first person to file for a patent at the patent office receive the patent. Is it true or false?
True, sir.
Most probably true. 3, if you have a patent on the technology, you have unlimited right to use it. True
No,
or
sir. False.
It's false, because your rights to a patent is only up to what you claim to be yours in the patent. Filing for a patent is free. Is it true or false?
False.
It costs money. It has fee that you need to pay.
How about Google Patent, sir?
Apa benda?
Patent. Google Patent ada juga, sir. Patent dekat Google.
Apa benda?
Untuk patentkan kita punya ni, sir.
You
IP.
We have to patent to the patent office.
Oh.
For example, dekat my IPO in Malaysia is my IPO. The patent actually that you have to file in each country that you want to protect. If you want to protect in US, you have to patent in the USPTO, US Patent and Trademark Office. If you want to patent that in Japan, you have to patent in the Japan Patent Office. If you want to patent in to protect in Malaysia, you patent in Malaysia. If you want to patent in the country under WPO, World Patent Organization, then you have to patent at WPO, so it covers under various countries. So patent actually is bound by the geography, which country that you want to protect. Types of patents. Basically, that you have two types of patents. One is the utility patent, and another one is the design patent. A utility patent is for anyone who discovers new and useful process, machines, article of manufacture, composition of matter, or useful improvements thereof. That is utility patents. So it is not an invention. Okay. A design patent may be granted to anyone who invents a new, original, and ornamental design for an article of manufacture. So design patent is an invention. Utility patent is not necessarily an invention, but a useful improvement thereof. Okay. Most probably that this normally will be in the test, in the exam normally. These are the three conditions for the utility patent. To get the utility patent, the idea must be novel, new, nothing like it exists. Basically, that is an improvement, but that improvement is new, it's novel. Okay? It doesn't have something which is, it doesn't have to be an invention. And that idea, okay, must be non-obvious. What does it mean by non-obvious? What it means is that if another engineer with the same experience as you, with the same qualification as you, with the same knowledge as you, is not able to come up with that idea, therefore, that means that it's non-obvious. So no expectation that another person would be able to develop it based on the current technology. So that new idea with the current knowledge that other engineers has, he will not be able to come up with that idea. But you come up with that idea. So therefore, it complies with the non-obvious requirement. The third condition is that useful. That idea must perform something useful and be able to reduce it to practice. That idea first must be useful, must perform something useful, and second, it can be practiced. Not just an idea that cannot be make it into a practical. It has to be practiced. Clear? So these are the three conditions of the utility patent. New, non-obvious, and useful. These are the elements of the patent. Basically, that in the patent, you must have these elements. First, citation of the prior arts. The list of similar patent and publicly reported technology. So you have to list out the patents that you use in coming up with your new idea. And what are the technology that is used? The second element is the description of the invention. You have to describe how it's operate and how it will reduce to practice. So you have to tell, you have to disclose about your invention. You cannot hide. If you hide, then it's not protected. So you have to tell what you have done, what your idea is all about, what your invention is all about. Then you go into claims. You claim which part is yours, legal description of the invention and its uniqueness. You claim this is yours. There are a few claims, and that claim actually is the one that is important. Those are the one that is that will be protected, not the part of description and whatnot. This based on the claim that will define the scope of your protection. The patent is good for 20 years, and patent only gives owner a right to sue others if they infringe upon it. And the patent office will give you a certificate. And you, as the owner of the patent, must protect your own patent. The government will not protect it. The government just keep a registration of the patent, registration of the patent that is being registered, who owns it, and how long it covers. Then, if there is infringement, you are the one who has to sue the person who infringed your patent, not the government. So these are the things that you cannot patent. Discoveries of material or substances already existing in nature. But this actually being what do you call it, being made a bit more loose now. For example, the patent of basmati. Basmati is in nature, but in US, they allow to patent the basmati rice. Even tongkat Ali, kacip Fatimah, those are actually herbs available in our forests. But through the US patent office, they're able to patent those kind of findings. You cannot patent scientific theories or mathematical methods. The third one is plants and animals, other than microorganisms and essential biological processes for the production of plants and animals. So basically that the basmati rice, they patent through the process of productions of plants. Schemes, rules or methods such as those of doing business, performing purely mental act or playing games, you cannot patent those. Method of treatment for humans or animals, or diagnostic method practiced on human or animals, this also cannot be patented. The drawbacks of the patent. I personally, I'm not for patent. I'm against patent. I'm more of a trade secret. The drawback of a patent is because this. The owner must be vigilant in defending a patent and may have to initiate legal action to do so. So you have to spend money to protect your patent. And once patent is made public for all to see on the government website, so everybody can learn from your patent. This is actually what the Chinese, the Taiwan, the Japanese and the Koreans did. They study the patents filed in US Patent Office. They study all those patents. Even actually they hire consultants to help them. One of the consultants is actually my guru on this area, on this systemic innovation. That this consultant will go through, will study all the patents with regards to the technology, a certain technology, and will write reports for the Chinese companies or Korean companies that hired him to study the patents. So from that study of the patents, what the Chinese, the Koreans did was that they find ways how to circumvent those patents in coming up their new products or new design. So basically that they use patents for education, for knowledge. And now you see that the Chinese and some of in the areas that they are ahead of the Americans. For example, the 3G, the Huawei. They study the technology, the previous technology which is available in the patent, and they are now coming up with their own technology. That even this, what do you call it? If you look at, if you read in the internet, the conspiracy theory that they say that this COVID-19 is actually a cover-up for the Chinese to install the 5G systems. And they say that some of them says that this COVID-19, this virus, is actually the result of the radio wave from the 5G systems. But those are all conspiracy theories which has no proof. But that to show you how far that the Chinese has evolved, has improved in terms of technology. So they use patents, which is filed by others, as a source of knowledge for them to study and then come up with their own ideas. So that's why I am actually against patent. I prefer the alternative way, which is the trade secret. The trade secret is basically that you protect your formula, your technology, without telling any other people. An example of a trade secret is the Coca-Cola. Nobody knows the recipe to come up with the Coca-Cola drink. Nobody knows, because that is a trade secret. It was never patented, it's never published anywhere. The second trade secret is the KFC. The recipe for the flour to coat the chicken, that is also never published anywhere. It's a trade secret of KFC. If you buy this flour, whatever, for frying the chicken in the supermarket and whatnot, still the taste are not the same as the KFC chicken. So those are the example of trade secret. Okay, any question on this? No question, I continue. The trade secret is that confidential information not available in public domain. The companies employ to protect intellectual property to hold them as trade secret. The idea must be kept secret so that others cannot find out about it. How you protect information? So you just allow one or two people to go into your manufacturing facility and put in those secret ingredients, for example. And they have non-disclosure agreement that the person that entrusted with the knowledge, with the secret, must sign a non-disclosure agreement that they will protect that information, will not reveal those information to anybody else until they die. And one who breaks a non-disclosure agreement can be held liable, legally liable, and you can sue the person if they break the agreement. So that is how you protect the trade secret. And more of this, of trade secret than the patent. Copyright is another one. It's a form of protection provided to the authors of original works or works of authorship, whether it's a published or unpublished. So copyright is a work of art. You protect work of art. Software is considered as work of art. Protect published works such as books, articles, software, musical work, artistic work, films, and whatnot. Others cannot distribute copyrighted material without permission of the owner. And there is no need to register of copyright What you need is that you need to prove that you are the owner of that copyright. And ownership can be transferred or traded. You can transfer the ownership to anybody else. And normally, if you look at the textbook, you see that copyright, you have that symbol, the C in the circle, copyright, who owns the copyright and what year. Okay? So that is how you claim your ownership. And actually, copyright, actually you can file the lawyer's office to be registered actually. And copyrights are good for how many years? Try to find how many years. Of course, it's longer than the patent. Patent just now we mentioned about 20 years, 20 or 25 years, somewhere like that lah. This slide is an old slide, so maybe some of the information actually outdated. The numbers are outdated. Right? What I'll do is that maybe I will update the information, because the last session was about 2 years ago. Actually, I update these slides. Right? So one way, the poor man's way of protecting a copyright is that by, let's say, you have a software that you do. So you print out the source code. Then you put in the envelope and you address that letter, that package to yourself. So you send through the registered letter so that you have a record of who is the sender, who is the receiver. When you receive that registered letter, you don't open it. You keep it. So when there is infringement by somebody of that copyright, you can use that source code that you send to yourself in a sealed envelope in the court to prove that that is yours. That is the poor man's way of doing the copyright protection. Copyright protection in Malaysia is governed by the Copyright Act. There is no system of registration for copyright in Malaysia. Copyright are good for the lifetime of the holder plus 50 years. For a company, it's good for 75 years. See how long is the copyright protection. Another one is trademark. It's a sign, a logo, or a brand. The sender of a trademark uses his mark to identify himself to the world as the owner, manufacturer, or simply as the sender of a message. The trademark protection is 10 years. For the period of 10 years, and no expiration date if renewed. Then after that, you can use that. The first registration is 10 years. Then when you renew, there is no expiration date anymore. So, does Malaysian registration give protection abroad? The answer is no. I mentioned just now that the patent, trademarks, all those are geographical boundary based. So no, if protection of trademark is required in other countries, it will be necessary to apply for registration separately in each country. However, a Malaysian application can be used as a basis for claiming priority in countries which are party to the Paris Convention and World Trade Organization. Trademark, how to apply? Before applying, applicants are advised to make search before submitting application to avoid applying for identical or similar of trademark file earlier. All search can be done at the My IPO at a rate of 20 ringgit per hour. Who may apply? Anybody can apply, whether they are Malaysian or not. Okay. And when you talk about patents, trademarks, patent or copyright, you have to talk about reverse engineering. Reverse engineering is really a method that you use to determine the competitor's trade secret, for example. For patent, are you allowed to do reverse engineering of a patent? Are you allowed to do reverse engineering of a patent?
No, sir.
You cannot. But many people are doing reverse engineering of a patent. For example, like a Chinese companies, Korean companies, they used to do that. They reverse engineer the patents. And from there, they learn and they come up with a new thing. Right? Reverse engineering is a device or process. It's taken a process of taken apart of other people's product to understand how it works. The question is it legal to reverse engineer another company's product to reveal their trade secrets? Is it legal?
No, sir.
It is illegal, actually, but many people do it. They reverse engineer. They reverse engineer. Then after that, they come up with a new one, which a bit different than the original products. So the answer is legal if the information is obtained through legal means, but one must be careful with the information that is obtained and not copy it unless legally allowed to do so. So, in general, it is illegal, but it becomes legal if you obtain through the information is through legal means to reverse engineer. Digital Millennium Copyright Act of 2000 prohibits breaking technological protection, i.e. encryption. So, reverse engineering and encryption is illegal under the Digital Millennium Copyright Act. So, the entity which taking care responsible for registering or keeping the register of the intellectual property in Malaysia is My IPO, is the Intellectual Property Corporation of Malaysia. It is an agency under the Ministry Trade, Cooperative and Consumerism. Prior to 1983, IPR in Malaysia was administered by Pejabat Cap Dagangan dan Jamin Hak. This office changed its name to Pejabat Cap Dagangan dan Patent in 1993 and was placed under the jurisdiction of the Ministry of Trade and Industry at the time. In 1990, the ministry was restructured and the office was placed under the Ministry of Domestic Trade and Consumer Affairs. Okay, and it's changed to the name of Intellectual Property Division. And the division was tasked to administer the Patent Act 1983, the Trademark Act 1976, and Copyright Act of 1987. So My IPO actually that The objective of my IPO is that to respond to the development. Basically, that is now is to take care of all issues related to the IPR. To respond to the development of intellectual property at domestic and global level, the division was corporatized in 2003 and now known as the Intellectual Property Corporation of Malaysia, with the enforcement of the Intellectual Property Corporation of Act 2002. Then after that, it rebranded PHIM to become My IPO in 2005. So now we know them as My IPO. The office is actually at the UAE Bangsa. So this is the office, UAE Bangsa. So any question? We are done on this, what do you call it, on this part. So next week we can go to the ethics. Any question?
No, sir.
No. So everybody clear on the, what do you call it, on this on the topic so far? No question?
No, sir.
Oh, so we are now at 11:04. So we can stop here if you want, because I don't want to continue to have a very long lecture, because it's online. So siapa yang buka whiteboard tu? So okay. Any, kalau tak ada, if there is no question that we can what do you call it, so we can stop for today.
All right, sir.
Okay.
Baik, sir.
Okay, so all together we have 22. Siapa yang tak ada, saya tak ambil pun lagi the attendance. So I will stop this recording and I will take the attendance. Okay.
Okay, sir.